of the accused's retention in lawful custody.
An aspiration that was made on record by the accused person, and we adopt.
And this goes to the members of the gallery. Kindly do not.
Thank you very much, Your Honor. Although I don't understand what you term as political phrases, I still thank you for this opportunity, Your Honor. Your Honor, having heard from all the submissions under these abnormal circumstances, I want to emphasize what I said, that it is not me on trial, Your Honor. It is the court itself on trial. And Your Honor, no matter what you decide in that court, whatever you decide, Your Honor, that is not my business. My business is standing for the truth. My business is standing for what is morally right. My business, Your Honor, is standing for what is morally beneficial to you, to me, to those people that are persecuting me under the guise of prosecution, and to all the people of Uganda. And Your Honor, if standing for what is right, if standing for truth is going to earn me my freedom, I will thank God for it. But Your Honor, if standing for what is right is going to keep me in this prison, then I will thank God even louder. After all, I have a lot of work to do, even here in prison.
The use of video conferencing is a welcome development. In this era of science and technology, you cannot oppose any form of technology, and the technology must be welcomed. However, the technology must not be used to abuse legal processes. What happened today was a clear abuse, because the law that allows the use of technology in our courts is very clear. If you are going to use technology, you have to make an application, and you must give a copy to the other party, and the other party must be given an opportunity to reply. In this matter, there was no application. We were just ambushed. So what we are opposed to is abusing the system of video conferencing, abusing the law, as we have seen today. Otherwise, by and large, there is absolutely nothing wrong with the use of technology. Now, when you read the law that governs the use of technology in our courts, it's very clear. You can only use it, one, for disability. If the parties involved in a trial have challenges of disability. Number two, if they are outside Uganda. Number three, for security reasons. Okay? Now today, none of those reasons was given in the court. So that tells you that the reason today had nothing to do with video conferencing, but it had everything to do with the politics. The fear of the BOBIWINE factor. Okay? Thinking that once you get BOBIWINE to Uganda Road Court, which is Central Business District, you are going to paralyze, the area. But we are glad that finally he has been granted bail. We are also glad that the magistrate agreed with our considerations. Of course, the requirement that he should not engage in unlawful demonstrations is strange, because who determines what is unlawful? If you leave it to this partisan police that is at the forefront of violating people's rights, you are going to create a situation where BOBIWINE will never be free in this country. So it was important to clarify what amounts to unlawful demonstration. Is it as determined by police or as determined by court of law? But the primary concern here is the freedom, is the liberty of our client.
How are you going to guarantee that your client has left prison?
Well, the procedure is very clear. From here, we are going to Luzira with the court documents duly signed by all the sureties and the officers. We will show them to court, to the prison officers, and it is the responsibility of prison officers to release the client to us. Prison has no authority to keep a person who has been granted bail, because keeping a person in prison is on an order of court. not another person. So we want to guarantee that from here, once we show those documents to the prison authorities, we will access our client and take him to actually today we are in Parliament. From Luzira we will come straight to Parliament because he has to be in the session.